Okay. Hello, everyone. Assalamu alaikum and good afternoon in DC, I know, because in Turkey, not like this. I'm honored to have this opportunity to share my work with you today. My presentation is about the pre-implantation genetic testing or diagnosis in Islamic law beyond medical benefit. During my presentation, I will use the abbreviation PGT for the pre-implantation genetic testing. Uh, so hmm. IVF creates embryos outside the womb, and PGT evaluates these embryos before transfer in order to prevent hereditary disease. Yet, because the PGT operates in the in vitro embryonic stage, it raises major ethical and juristic questions. My argument is that these questions cannot be answered only through medical benefits, but must be addressed through embryonic status, ethical dilemma, and legal methodology. So here, IVF is a reproductive technique in which fertilization takes place outside the womb of the woman, creating embryos in vitro. PGT is used at this pre-implantation stage before embryo transfer. Its main aim is to identify hereditary disease and prevent the transfer of affected embryos to womb. However, PGT is not a single uniform procedure. It includes different methods, and some of these may interfere with embryonic development. In addition, false positive and false negative results may lead either to unnecessary elimination of healthy embryos or to the transfer of affected ones. So the issue is not only what PGT seeks to prevent, but also what it may do to the embryo itself, since the embryo is not merely biological material, but a being that may already carry moral and legal significance. The ethical debate surrounding PGT begins with embryo status. If the embryo is recognized as deserving some degree of dignity or protection, then embryo elimination, possible harm, and instrumentalization cannot be treated as morally neutral medical acts. This is why the discussion is not only about the disease prevention, but also, for example, instrumentalization. What is it? Because thanks to this technique, embryo can be selected to help treat an existing sibling. So embryo called as a savior sibling. Another one, and it's autonomy concerns. Because routine or standardized use of the testing may pressure parents' decisions and undermine gene autonomy. Another one, justice problem. Because of the fact that this technique is very expensive, limited access to this technique can deepen social inequalities. Eugenic, meaning that using PGT beyond the medical need may lead to enhancement practices and the gradual shift toward eugenic selection. Eugenic refers to the idea of selecting or shaping future generations based on preferred traits. Another one, false results, wrongful elimination meaning. And last one is direct harm. It's triggered by the testing procedure itself, because these tests, that some techniques can be truly damage to the embryo itself. Ethically, as a result, PGT is not only about disease prevention, it is about how reproductive benefit is balanced against embryonic protection. From the embryo to janine, why this issue becomes a key question. In Islamic law, the ethical dilemmas raised by PGT reappear through the question of embryonic status, like as the ethical dilemmas. It's a main question. In classical Islamic law, the closest category to the in vitro embryo is the janin. The janin is not morally natural. This means it is not just a theoretical issue. It comes with protection and legal implications. So, the first question is not simply whether PGT is useful, but when and in what sense the embryo may be called a gene. So, even if the embryo is not treated as fully identical to the classical genin, once some degree of dignity, life value, or legal protection is recognized and practiced that may harm, eliminate, or instrumentalize, it becomes a matter for Islamic legal analysis. Why conceptual clarity comes first? In 1 minute. In a contemporary issue, such as PGT, it is neither realistic nor necessary for all fatwa bodies to reach exactly the same conclusion. What matters more is the coherence of the argumentation. Conceptual clarity is therefore essential because it is what makes juristic reasoning credible and trustworthy for Muslim audience. This is especially important in the case of embryogeny status, because clarifying that status shapes not only the moral balance of maslaha, but also the textual and juristic basis on which rulings concerning the embryo are built. Here, I will examine selected fatwa bodies through the lens of conceptual clarity. First one, the Jordanian General IFTA Department is conceptually significant because it adopts a protective approach toward embryonic life. Yet, in its IVF-related fatwa, it functionally brings the in vitro embryo close to the category of genin, while still permitting the identification of healthy embryos and the elimination of unhealthy ones before transfer to womb. By contrast, intervention becomes more restricted once the embryo or fetus is in the womb. This reveals a conceptual inconsistency. If the in vitro embryo is close enough to the genin to receive protection, then the different treatment before and after implantation requires much clearer explanation. And a similar conceptual problem appears in the rulings of the Turkey's Higher Council of Religious Affairs. The council recognizes a right to life from fertilization onward and adopts a protective tone toward the embryo. Yet it does not clearly explain how the classical concept of genin applies across in vitro and in vivo states. In vivo meaning that during the womb of the woman. So the problem is not the absence of protection, but the absence of a sufficiently explicit conceptual framework showing how that protection is distributed across embryonic stages. Taken together, these examples shows that conceptual protection is often affirmed, but its operative meaning remains underdefined. These conceptual things brings us to key question. How do we move from embryonic protection to legal permission? And what role does necessity play in this transition? Many contemporary fatwa bodies assign some degree of moral or legal status to the embryo, yet still permit PGT in certain cases. In many of these rulings, permission is justified through necessity, darura. But necessity in classical Islamic law is not a concept to be invoked casually. It is not a broad appeal to benefit, convenience, or anticipated advantage. It is an exceptional concession that requires clear conditions and limits. Methodologically, this means that fatwa bodies cannot simply say that PGT is permitted because it serves treatment or prevention. They must explain how they move from embryonic protection to permissible intervention. Because embryo has some degree of the ethical status. They must explain how they move from, yes, I said that. In other words, they must show what kind of necessity is being invoked, why it is strong enough to override embryonic protection, and what precise limits govern such permission. More importantly, before reaching a conclusion of necessity, the ethical dilemmas inherent in PGT must be brought into the analysis. Embryo instrumentalization in cases such as severe siblings, the reliability of different testing methods, false negative and false positive results, possible harm to the embryo, justice in access that I mentioned before, these ethical dilemmas, and whether every reproductive interest can really count as necessity. If a fatwa does not sufficiently show that these issues have been weighted, it creates the impression that they have been bypassed. And if that happens, the route by which the fatwa arrives at necessity becomes unclear, which in turn weakens the ruling methodologically. A good example is Turkey's Higher Council of Religious Affairs, which recognizes embryonic protection that I mentioned before the slide, which recognizes embryonic protection from the fertilization onward. Yet when it permits PGT under necessity, it does not sufficiently explain why this case rises to the level of the necessity, what ethical considerations have been fully weighed, or what limiting principles keep that permission from becoming overly broad. And another example is Egypt. A related methodological difficulty appears in these fatwa council, where testing for severe or untreatable conditions may be described in broad terms without sufficiently integrating the risk of false results, unjust elimination, or the ethical cost of error into the reasoning itself. By contrast, Islamic Fiqh Academy, the center in the Jeddah, is noteworthy because it makes some ethical concerns more visible within its reasoning, including sample mixing, lineage, and reproductive integrity. This is methodologically important because it shows that fatwas on reproductive technologies can explicitly acknowledge ethical risks rather than relying only on benefit-based permission. The problem is not simply as a result. The problem is not simply that necessity is invoked, but that ruling often does not show how it has arrived at necessity rather than at a weaker category of need, preference, or reproductive interest. This is precisely why the classical distinction between haja and darura becomes crucial. Not every benefit qualifies as necessity, and not every difficult case justifies exceptional intervention. In the case of PGT, the real question is whether the claimed interest is truly a necessity, merely a need, or only in some cases a need elevated toward a necessity under strict conditions. This is why test reliability, the nature of the intervention, and the ethical cost of error are not secondary. They directly affect whether the claim of necessity is actually unjustified. So the real issue is not only whether PGT is useful, but whether the path from the embryonic protection to legal permission is argued in a conceptually clear, ethically serious, and methodologically coherent way. Thank you for listening. Yes.
Thank you so much. Thank you
Thank you
so
for
much.
attention.
Thank you so much, Sister Bishra Hocam, for this insightful presentation. We will move on to the second presenter now, and then we will have the Q&A at the end of the session. So Dr. Sumaya Olgat is not available, so she will not be able to join us today, and I think she had an urgent matter. And now we have the third speaker, who is Hadil Debas. If she is here, if you can turn off the screen share, Bishra Hocam.
Okay. I will share now my PowerPoint.
Yeah, perfect. Let me
Thanks.
make you a co-host.
Okay.
Yeah. So you have 10 minutes plus 2 minutes, and then the Q&A will be at the end of the session.
Okay, thanks so much. Just 1 second, please. Mhm. Okay. Okay, first of all, Assalamu alaikum wa rahmatullahi wa barakatuh. Thanks so much for this opportunity for us. My subject is about Islamic unity in modern legal theory, the contribution of Sanhuri and Ashawi. Okay, first of all, please let me introduce myself. My name is Hadil Divas. Pardon. I'm Palestinian. Now I make my PhD in Marmara University in Islamic jurisprudence. My civilization is about Islamic political jurisprudence, and for this civilization is about the Islamic political theory. My master thesis is about the mechanism for preventing despotism in the Islamic political in the Islamic political system. And now my PhD about the 20th century Islamic political theory, concept of Shura through the intellectual model for Dr. Tawfiq Shawi. In Palestine, I work in Fatwa Council. Now I start my presentation. This PowerPoint have 4 parts. The first one, academic and methodological formation about Sanhuri and Ashawi, education, methods, and scholarly method. The second part is about Islamic unity from Sanhuri vision, and the third part is about Islamic unity from Tawfiq Ashawi vision. The final one, comparative and legacy. Okay, for the first part, yes, about Abdurrazzaq Sanhuri. Abdurrazzaq Sanhuri was born in Alexandria in Egypt in 1895. After that, first of all, he was graduated from Al-Kideval School of Law in Cairo. After that, he went to France, University of Lyon. He makes 2 doctoral dissertations. The first one about the contractual freedom in English law, and the second one is about the Caliphate and a League of Eastern Nations. For the methodological approach, we can see that these points, Abdurrazzaq Sanhuri have a show and a point about comparative law as the bridge between Islamic and Western traditions, and also comparative legal analyze Islamic fiqh, يعني الفقه الإسلامي vs Western law. After that, we also say the analytical inquiry too into Islamic historical legacy, and the final one, immutable principles about the thawabit and the متغيرات. When we come to Tawfiq Ashawi, we now have about the biography. He was born in Egypt in 1819, and the first stage in Cairo University, he studied in the Faculty of Law. After that, he also went to Paris. And studied French public law and administrative theory. As a career, he was made as a judge and legal secular in Egyptian State Council. After that, he was also influenced by Islamic consensual thoughts, political theory, and extensive engagement with comparative consensual systems. For the methodological approach, we can say Shura as a comprehensive theory in the foundation of Islamic governments, and also a consensual Islam, Quran and Sunnah as a supreme consensual sources. And he is also criticized of the legal secularism as a culture aligned to the Muslim societies, Islamic law as a complete self-sufficient system of the public governance, and a bridge between the classical fiqh, siyasa, and the modern conceptual law. For the part two, the unity from Abdulrazak al-Sanhuri, we can say legal modernism and the caliphate and the Arab civil law. For basic points, we say that caliphate re-imaged. He says and he abridged for doctoral thesis. He was wrote it on 1824 الفقه الخلافة وتطورها, and he's also response to abolition of Ottoman Caliphate at the same year, rejects theoretical monarchy, rejects secular nationalism, and the process of that Federate League of Several Muslim nations states. Khalifa as a constitutional head, not a absolute ruler, and also here just 1 minute, please.
No worries, take your time.
Thanks so much. Civil codification as a unity, and also here the I just make it yes, Islamic law as a living system. The difference between ibadat, domains of specific ulama, and the muamalat, civil transaction. Here are the main points about all of these points. We now can okay. For the Shawi vision, for the Shawi vision, it's about conceptual thought, shura-based conceptualism, and the criticize of legal secularism and the historic unity. Shura in the Islamic foundation of governments is the base point, not important democracy, but Islam's own democratic principle. Quran and Sunnah as a supreme conceptual sources, and Islamic unity through shared conceptual identity. In the second point, for the point that legal to secularism, we can say important secular codes alienate Muslims from their legal identity, and also legal secularism serves legal secularism serves cultural colonization, not strategy, not for the modernization, and also for the historic holistic unity. Shall we have most of projects about the unity, like al-fiqh siyasa, Islamic political jurisprudence, as a practical converts tools, and OIC as a similar bodies as step towards institutional Islamic cooperation. Law as medium through which the Ummah express its collective identity. For Shawi, we can say unity of the Muslim nation cannot be realized without unity of its legal and constitutional order. Okay, now for the third, for the last part, just the differences. For Sanhuri, primary domain is about private law, and for Shawi is a public law. But also we can say for the Islamic law rules, Senhuri focus on inspiration for civil code, and the Shawi focus for super of conceptual norm. For Senhuri, Western law was as adopted to Islam, but shall we say? But shall we also deal like a critical analysis of public law? For the unity of mechanism, Senhuri shared civil confidential sorry, across Arab states.
Excuse me, can we wrap it up in 1 or 2 minutes?
Yeah.
Okay.
The last one. That is the last one. And for Shawi shared Islamic constitutional identity. For the Caliphate, Senhuri was Federated League of Eastern Nations and the Shawi Shura-based Islamic constitutional state, and the legacy, as all of us we know, Egyptian civil for Senhuri, and now it was for the Arab civil law family, and the Shawi Islamic constitutionalism and OIC legal discourse. Yes. The last thing, Senhuri was, as we say, is the Arab يعني أبو القوانين العربية, the Arabian judge, and for the for Ashawi, the last one, he was focused on the unity and the Islamic constitutionalism. Thanks so much for listening.
Thank you so much. Thank you so much, Hadil. Hadil is the right pronunciation, right? Hadil Dabas.
Yeah, Hadil Dabas, as I written here.
Good. My Arabic is as good as your Turkish, I think.
My Turkish, it's really so much good for now
No
from
doubt
the
about
English,
that.
because yani bir dakika sadece bir dakika Türkçe konuşabilir miyim?
Sorun yok. Ağzınıza
Benim
sağlık. Thank you so much.
teşekkür ederim. Benim Türkçem İngilizcem daha iyi, çünkü tüm dersler artık daha Türkçe yani odaklıyorum. Ama gerçekten güzel bir fırsat. Teşekkür ederim.
MashaAllah. Thank you. And we hope to host you here at the Diana Center of America in person, inshallah. Thank you for the
İnşallah.
presentation. Now we'll move on to the third speaker of today and the fourth presenter announced on the schedule. So Saliha Sultan Yazıcı is with us to talk about the Sufi tradition, Ibn Arabi and Iblis in Ibn al-Arabi, like Iblis in the different Sufi traditions. I think her presentation, she's able to share the screen. So here you are. You have 10 minutes plus 2 minutes, and then the questions and answers for your the Q&A for your presentation will be at the end of the session.
Assalamu alaikum. My name is Saliha. It's a big pleasure to be here today. I will present my paper entitled Interpretations of Iblis in the Sufi Tradition, Ibn Arabi's Ontological Vision. Before the beginning, I would like to briefly mention the miniatures on the cover. I choose them to show the visual variety of Iblis in Islamic art. As you can see, there are different types of Iblis. For example, at the second one, we see Iblis as a serpent, and the third one, we see him as a wise old dark-skinned man. This variety is important because Iblis is not a simple figure. He has been imagined and interpreted in different ways in Sufi and theological thought. 1 minute. Ben geçmiyor muydum? Burada basmayacak. Let me briefly show the outline. I will move from the general problem of Iblis to the Quranic background, classical Sufi text, and finally Ibn Arabi's interpretation. This will be the main part of my presentation. In Islamic thought, Iblis is not only a figure of disobedience, his story is also related to evil, divine will, human responsibility, and Tawhid, it means the unity of God. Um, it makes Iblis story and the problem of Iblis related to philosophy, theology, and also Sufism. There is important questions, but one of them, if nothing happens outside God's will and power, how should we understand Iblis's refusal? This is connected to the term al-fa'il al-haqiqi. It means the true agent. In Sunni theology, God is understood as the true agent of everything. My main focus today is the Sufi reading of this problem. I will follow three main questions. First, is Iblis only a moral enemy? Second, how is he understood in the Sufi tradition before Ibn Arabi? And third, what is distinctive about Ibn Arabi's interpretation of Iblis? Before the texts, I would like to briefly mention a small literature note. Iblis has been studied in Quranic exegesis, theology, and Sufi psychology in Western, but more detail and much more than the Eastern studies. My paper is focused on especially Ibn Arabi's interpretation. In the Quran and the Hadith, the story of Iblis raises two main questions. The first question is about his nature. Is he an angel or a jinn? Surah Al-Kahf states that he was from the jinn, but this question is not really connected with my topic, so I'm not going to stay at that. The second question is about the true agent of rebellion. In Surah Al-A'raf, Iblis says, because you have led me astray. This expression opens the question of divine agency. At the same time, the Quran Quran presents Iblis as a manifest enemy, like that. Iblis in classical Sufi text. Before Ibn Arabi, Iblis is mostly discussed through pride, enmity, the nafs, and refusal to repent. In Al-Qushayri and Al-Hujwiri, he is presented as a warning for believers, as the Quran says. The most important point is pride. It means kibr. Iblis had worshipped God, but his pride caused his fall. For Sufi authors, worship alone is not enough if it's mixed with pride. Prophet Adam turns back in repentance while Iblis remains in refusal. I should also briefly mention Al-Hallaj. He presents Iblis as a tragic lover and a defender of Tawhid, but even he accepts that Iblis still falls into pride when he sees himself as superior to Prophet Adam. Now I will turn to the main parts, Ibn Arabi's understanding of Iblis. He doesn't simply praise Iblis and he doesn't reduce him to a moral enemy. Rather, he tries to understand Iblis within a larger vision of being, divine mercy and the divine names. So the question becomes, what does the role of Iblis mean within the divine order? Being evil and Nafas ar-Rahman. To understand this, we first need one basic idea. For Ibn Arabi, being itself is good. Evil is not an independent reality. It's connected with lack and limitation. Here, Nafas ar-Rahman, it means the breath of the All-Merciful, is important. In Ibn Arabi's thought, the whole cosmos comes into existence through this divine breath. So, because Iblis exists, he also has a place within this divine order. He is not outside God's will and mercy. Now we come to the K concept, al-mudil. It means the one who leads astray. For Ibn Arabi, Iblis is not an independent source of evil. Rather, he is a locus of manifestation. It means mazhar, of this divine name. This means that misguidance is included within God's will and the manifestation of the divine names. Iblis leads astray, but he doesn't act independently. He is understood through the divine name Al-Mudil. Iblis refuses to prostrate because he compares himself with Prophet Adam. He says, "You created me from fire and you created him from clay. It's me. خلقتني من نار وخلقته من طين." For Ibn Arabi, this comparison is much more than this. There's a deeper comparison. Prophet Adam is the comprehensive locus of the divine name Allah. He gathers beauty, Jamal, and majesty, Jalal. Iblis, however, is connected especially with majestic names such as Al-Mudil. His vision is partial. For this reason, Iblis' mistake is not only pride, but also a failure of understanding. To conclude, in mainstream Sufism, Iblis is mostly a moral and spiritual enemy. His main mistake is kibr. Al-Hallaj presents him as a tragic lover, but he also thinks that his mistakes is kibr. Ibn Arabi offers another way. He interprets Iblis through the divine name Al-Mudil. So Iblis is not an independent power of evil. He is understood within God's will and the manifestation of the divine names. This is the main point of my presentation. Ibn Arabi turns the story of Iblis from a simple story of rebellion into a question about divine names, evil, and Tawheed. Thank you.
Thank you so much. I think that was all the presentation, right? Are you done?
Yes, I
Did you
done.
have something to add? Did you
I
have
finished
something
the
to add?
presentation.
No? Okay.
No.
Thank you so much, Saliha.
You're welcome.
And now we will move on to the other presentation, and that would be our last presentation before the Q&A and reflections. Nurefshan Çalışkan Ordu, are you here?
Yes, I'm here.
Okay, let me share the screen with you if I can. Make you a co-host. You have your presentation? Perfect. So the stage is yours, and you have 10 minutes plus 2 minutes. And then after the presentation, we will have the Q&A.
Okay, just a second. Yes. Assalamu alaikum wa rahmatullahi wa barakatuh. I am Nurefshan Çalışkan Ordu. I am a PhD student in the field of Islamic and Turkish philosophy at Istanbul Medeniyet University. First of all, I would like to thank the organizers of this Congress, the Diyanet Center of America and the Diyanet Islamic Research Institute, for providing us with the opportunity to share our work with other researchers in the field. The title of my presentation is The Problem of the Possibility of Objective Knowledge Between Jurjani's Theory of Nazm and the Semantic Tradition. Actually, my research started with a question I had while reading about contemporary philosophy of language. I noticed a crisis of objective knowledge in these debates, and I wondered, is there an equivalent to this crisis in the Islamic world? And if so, what kind of alternative paradigm did they create? Usually, when we talk about the philosophy of language, the 20th century semantic tradition of the Vienna Circle comes to mind. This tradition focused on the formal rules of language to remove ambiguity from philosophical discussions. As a result, it didn't accept any human or metaphysical elements as things we can objectively talk about. However, if we limit the philosophy of language to this modern and Western-centric view, we ignore other traditions from different historical backgrounds and regions that also discussed language. The language studies in the Islamic world are one of these ignored traditions. This realization led me to Abdul Qahir al-Jurjani. He is a prominent Arabic linguist who introduced a formal approach to language with his theory of Nazm. Therefore, I decided to compare these two traditions. My research questions are, can the objectivity of knowledge be based only on the internal structure and formal rules of language? And the second question is,
How does expressing our knowledge of reality within the synthetic limits of language affects its truth value? And the third one, what new perspectives can Giugiani's approach bring to modern studies in the philosophy of language? To answer these questions without falling into anachronism, I try to evaluate both traditions within their own historical contexts. For my methodology, I use the tahqiq method. In the Islamic tradition, tahqiq generally means to prove something with strong evidence. However, the way I use it in my research is based on a layered structure developed by the Tahqiq Foundation in Istanbul. Here is how this layered structure works. At the core, we have the fundamental questions of each tradition. Next come two constitutive principles that the tradition uses to answer these questions. After this point, traditions separate from each other and build their own core ideas. At the ground of all this is the horizon of experience of a thinker or a tradition. To discover this horizon, we need to ask basic questions like what exactly is knowledge and what are the criteria for it? Today, I will use the tahqiq perspective to try to find the layers within the thoughts of these traditions. Then, since my time is limited, I will focus on one common problem I have chosen and evaluate how these two different traditions answer it. When we look from the tahqiq perspective, we see that Giugiani's horizon of experience is not limited to only what we can observe. Theologically, he follows the Ash'ari tradition. So when answering the question, what is the source of knowledge, he would say that reason and true report, al-khabar al-sadiq, must be included alongside the five senses. As for Giugiani's core question, he basically asks this: how can we distinguish a sentence with superior literary value from a weak one? And his founding principle to answer this is that the Quran has a inimitability, إعجاز Quran. يعني. Of course, other schools in the Islamic world also accept this principle. However, the main idea that separates Giugiani from these other schools is this. He argues that eloquence is not found in individual words or in isolated meanings, but rather in the syntax or the construction of the sentence. The theory of nazm. Now, let's turn our attention to the semantic tradition. The term semantic tradition was coined by Alberto Coffa. He used it to describe the philosophers around the Vienna Circle between 1925 and 1935, who aimed to reach objective knowledge through semantics without using Kantian intuition. The horizon of experience for this tradition is limited strictly to the empirical world. They don't consider metaphysical knowledge to be objective knowledge that we can meaningfully talk about. Their fundamental question, which they share with some other traditions, is simply this: what is the source of a priori knowledge? Their founding principle is it's possible to develop a concept of a priori knowledge without relying on intuition. Finally, the main idea that is specific to the semantic tradition is this: the necessity found in synthetic a priori judgments comes from their conceptual nature. And now let's move on to a common issue that I believe both traditions address: the relationship between language and the world. In this regard, Giugiani criticizes the Mu'tazile tradition's correspondence theory of language. According to him, an utterance doesn't indicate the existence or absence of a meaning in the external world. Rather, it indicates the existence or absence of a meaning in the mind. This way, Giugiani separates linguistic signification from external reality. In linguistic signification, the main thing to focus on is whether it follows the syntax. That is, there should be no grammatical errors in the speech. However, just because a statement is grammatically flawless doesn't mean it directly gives us objective knowledge. This is where a concept he calls rational meaning comes into play. For Jurjani, rational meanings are those that the intellect accepts as correct and real. These kinds of meanings are mostly found in the words of truthful people, namely the prophets and their companions. Therefore, we can say that Jurjani developed a perspective on the language-world relationship that combines both formal and human elements. On the other hand, Ludwig Wittgenstein, representing the semantic tradition, separates the meaningfulness of a proposition from its truth. According to him, we can decide the truth of some propositions by comparing them with the external world. These are the empirical ones. For logical propositions, however, we do not need to compare them with the external world. We can determine if a logical proposition is true or false simply by looking at its syntax. And Moritz Schlick, another representative of the semantic tradition. He developed a system he called truth conditions. According to his view, if a proposition doesn't meet these truth conditions, meaning if it cannot be verified, it's not meaningful. For example, to Schlick, the statement, "there is a reality beyond my experience," is an unverifiable metaphysical proposition, and therefore it's meaningless. From this, it's clear that philosophers representing the semantic tradition don't accept metaphysical statements. They will only consider propositions to be objective if they follow the formal rules of language and empirically match external reality. In conclusion, the semantic tradition tried to build a formal language completely free from human factors by removing elements like pure intuition. They believed this was the only way to reach objective knowledge. Along with this, they thought that a proposition is only meaningful if it can be empirically verified with the external world. This led them to develop a view of language that completely leaves out any human or metaphysical elements. Jurjani, on the other hand, included human factors, like the speaker's intention behind the meaning, alongside the formal rules of language. He built this theory of nazm on this foundation. According to him, the main reason we put words together in a certain order is because of the meanings those words represent. In other words, a speaker chooses specific words to build a sentence because the words are exactly what they need to express the meanings in their mind. Therefore, we can conclude that objective knowledge is possible in Jurjani's system. And it means this: if a truthful person intentionally puts words together to express meanings that people can agree on, this can become objective knowledge. Ultimately, if we can say that we find the seeds of philosophy of language in Jurjani's work, then we need to do more to fully uncover the rich heritage of the Islamic philosophy of language. We must explore works in different fields like balagha and tafsir, and examine this tradition much more deeply. This kind of study can also help us create alternative paradigms for contemporary debates. So this presentation shows that Western-centric readings of the philosophy of language are not our only option. It proves that in classical Islamic thought, we can discuss the possibility of objective knowledge without excluding metaphysics or ignoring human factors. Thank you very much for you to listening.
Thank you so much for your presentation. And I think now we move to the Q&A session. I guess there was a presenter here who wants to, a listener here from our audience. He was in the room. Let me just Send it to him. If you have any questions or any reflection before I say mine, you can go ahead. I think very beautiful presentations. The first one, let me go back to my notes. The first presentation, which was a very technical one, you know, I have zero knowledge about embryo, about this, but I think I know from Tuba Baidar, if you know her, Sister Bushra, she also works about bioethics, the ethical part in fiqh. And I think this is a new phenomena in fiqh studies that she used to study euthanasia, you know. These are very technical things that I feel not confident talking about. But maybe I can ask you, how do we so what I understood from your presentation was that it is not about if it is permissible or not, the PGT, but it's about how you arrive at a conclusion through that reasoning. So it's about this. The presentation was about the reasoning rather than the actual fatwa or the actual one, the actual, how to say, ifta. So just let me turn this off. So how do we practically determine when the things turn from haja to darura, especially in biomedical cases? Because in fiqh, as you know, in the last 100 years, we had a lot of developments that our traditional classical fiqh does not count, really, right? So how do we determine practically, how do we determine in biomedical cases when the haja turns into a darura? And then I can leave the stage to other presenters for their reflections as well.
Thank you very much for your comment.
Did you get the question?
Yes, I get it.
Sure.
But when we in a minute, because another voices mixed. Okay. So yes, the Tuba Coach Baydar, she's my supervisor also in my doctor PhD thesis. I am a medical doctor. I'm graduated from the medical faculty, and then I started making PhD in Islamic law, and I'm at the term of the thesis. She's also my supervisor, I say. Yes, it's a really technical issue because of my medical background, I prefer to study on these type issues because acquiring the approach through the technical terms in medical faculty really good way. So I try to give some good things in this field. So if we come to your question, yes, in the bioethical issues, maybe you aware of some studies in all over the world. They try to determine the methodology. So we need the methodology, how we evaluate the daily issues like the PGTs and other classical issues. So we need a methodology. So yes, you asked me how we, for example, how a need elevated toward a necessity under these type conditions. Am I right? For example, if PGT is need, we call it a need because necessity means that the street is a not very wide area, necessity darura. So need is the lower than the necessity. So in the classical fiqh, there is some conditions, there's some rules, how need elevated toward the necessity under these type conditions. For example, we should firstly recognize the legal basis of these questions. For example, the embryo I mentioned before, and what is the source? Because of it, firstly, we should clarify the concept. We should first, I mentioned about in my presentation, we should make conceptual clarity. What is the corresponding of the embryo in classical fiqh? First, we should determine it, because the gene, etc., in classical fiqh found, but embryo not. So we should know the mahia meaning of the embryo. to compare with the genie, and then we can recognize the legal basis. And the other rule, hardship beyond ordinary hardship. So it's also another rule. And we shouldn't have any legitimate alternative to PGT. So what's the function of the PGT? In this step, we should know what's the PGT. Is it the only choice or not? Is it only choice to determine the anomaly of the embryo? When to say it's the exact thing, we should know the risk of these tests is found or not. So it's also the risky, it's also the technical thing. And the last step, certainty or dominant probability. So if we do PGT, the result is certain. And when we determine the embryo, animal embryo with this way, and we found animal's embryo. After that, is it finished, our problem? Like this. So in this type of question, we should firstly have to know the concept clarity, and then we should put this concept which the need or the necessity we should determine. So to do this, we should know this technique and mahia of this technique and the result of these tests, the false negative, false positive results, it is a zani or qat'i, the knowledge is also the issue here. So like this, my answer.
Thank you so much. Thank you so much, Sister Bishra. I think we have a few minutes. If we, I don't want to like take all the time, but maybe I think there was a person who was here joining in person. If he can ask if his question, I think he has a question before we conclude this panel. But either unmute or you can type the message. Both are fine.
Yeah, assalamu alaikum. Saleha, I had a question on your presentation on the interpretation of Iblis in Sufi tradition versus Ibn Arabi's viewpoint. If Ibn Arabi's idea of wahdatul wujud, or the unity of being, which means that everything comes from God, and evil is not fully real on its own, does that risk making sin and human suffering seem less serious?
Can you make it more? Can you repeat it, please? I couldn't hear well.
Yeah, it's a bit of a concept question, just like a reflection that I had. But if everything comes from God and evil is not fully real on its own, does that risk making sin and human suffering seem less serious? It's more of a reflectionary question that I was thinking of like while you were presenting. I don't know if you encountered that in your research or had anything to say.
Actually, it's human also have a responsibility on his actions, but Ibn Arabi says everything. I'm not sure how can I explain in English, but I will try. Everything that happened part of from creation, it should be good in some way. Maybe we can understand that from our small vision. I'm not, but it must be good because of this vision of Ibn Arabi. And also, for example, when we think the sin of Iblis, he's also it's a sin to not bow before the Prophet Adam, but he says he made this because of his creation, because he's مظهر of اسم المضل. Because of that, he made this. But he's part of the creation, and he has a also he has a part of mercy from God, and it's as the same as for all creation, like people and a jinn. It doesn't matter. I'm not sure I did explain or not.
Thank you so much, Sister Saliha. I think
You're
what I understood from the presentation and from your reflections is that model is like not something necessarily a dalala, is not something necessarily evil. It is the absence of hidayah. So it's the absence of the
Yes.
guidance, maybe. And this is, of course, a very deep and sophisticated perspective, difficult to understand at the first level for people who are not expert in this topic. But this is what I understood from that reflection and from Ibn Arabi. And I think it is in line with his overall philosophy, overall worldview of how he sees the world, that he sees the world mainly through love, through peace, and everything else is just absence of this. So it's not an action, it's just absence of. So if there is hate, it's an absence of love. If there is evil, it's an absence of khair, and it also is also one of the reflections of God that as you have said, and model, the one who misguide, right? Yeah, thank you so much. For the other presenters, if you have any other question or reflection, I would like to wrap this panel up and then conclude it if you don't have any question or reflection. All right. Thank you so much for joining us at the third DCA Graduate Student Symposium. We hope to host you here in person, and soon the videos should be available online, on YouTube, uploaded on YouTube, hopefully. And your papers, we will work on them. Make sure you send your full papers. Make sure you send your extended abstracts so that we can work on the publication process. Thank you so much for joining us, and have a good day.